I have watched federal authority fracture before, not through revolution or constitutional amendment, through a unanimous Supreme Court decision that no one saw coming and fewer still understood until enforcement began. The Supreme Court just issued a 9-0 ruling that eliminates the legal architecture holding federal and state law enforcement together. Every justice agreed. This was not a narrow ideological split. This was the entire court speaking with one institutional voice to tell the American public that the relationship between federal agents and state governments has been fundamentally rewritten. That unanimity is not consensus, it is inevitability. When the Supreme Court votes 9-0, they are closing a debate that should have been settled decades ago, but was allowed to drift through procedural shortcuts until the constitutional architecture itself began to collapse. The case is Arizona versus United States, though the facts center on Minnesota. Federal immigration agents conducted a raid in coordination with local law enforcement. Except the coordination was one-sided. Federal agents informed local police they would be operating in the county. Local police said they would not participate and asked federal agents to delay until state protocols could be followed. Federal agents proceeded anyway. Arrests were made, evidence was collected, prosecutions were initiated. Then the Minnesota Supreme Court ruled that every arrest was unconstitutional under state law because federal agents had violated state coordination requirements. The evidence could not be used. The prosecutions collapsed. And the United States government appealed directly to the U.S. Supreme Court, arguing that federal agents do not need permission from state governments to enforce federal law. The Supreme Court disagreed. 9 justices ruled that while federal agents can enforce federal law, they cannot commandeer state resources, override state procedural protections, or operate in ways that force state and local governments to facilitate federal enforcement against their will. This is the anti-commandeering doctrine rooted in the 10th Amendment. The principle has existed since the founding. But it has been eroded over decades through federal funding conditions, cooperative agreements, and task forces that blurred the line between state assistance and state compulsion. The Supreme Court just unblurred that line. And the implications go far beyond immigration enforcement. Federal agents now face a legal reality where they can enforce federal law, but only using federal resources, if state law requires advance notice, coordination protocols, or procedural safeguards. Before law enforcement operations, federal agents must either comply or operate entirely without state involvement. They cannot compel a state to help. They cannot override state rules. And if they violate state procedures while operating within state territory, state courts can exclude the evidence and hold federal agents accountable under state law. This is not theoretical. It is already happening. Within 72 hours of the ruling, law enforcement agencies in 6 states issued guidance clarifying that federal agents must now request coordination rather than inform of operations. Minnesota formalized a 48-hour advance notice requirement. California expanded its sanctuary policies to include a prohibition on state facilities being used for federal detention. Texas implemented a reverse protocol, stating that federal immigration enforcement would receive state support, but federal firearms enforcement would not. The result is a patchwork. Federal law is still federal law, but whether federal agents can actually enforce it depends on the state where the violation occurred, the county where the operation takes place, and the willingness of local governments to cooperate. Justice Thomas wrote the majority opinion. It is 47 pages of constitutional history showing that the founders explicitly rejected proposals that would have allowed the federal government to command state officials. The Virginia Plan, debated during the Constitutional Convention, included language giving Congress the power to call forth state officers to enforce federal law. That language was removed. The founders chose a system where the federal government would enforce its own laws using its own personnel. Thomas traced that principle through 2 centuries of case law. He cited cases establishing that the federal government cannot commandeer state officers, but they left open a question that has paralyzed lower courts for decades. What happens when federal agents operate within a state without asking for help, but their operations inevitably interact with state systems? The Supreme Court just answered yes. States cannot nullify federal law, but they can refuse to facilitate its enforcement. They can set procedural rules that apply to anyone operating within their territory, including federal agents. And if federal agents violate those rules, state courts can treat the violations the same way they treat violations by state officers. This is not nullification. It is non-cooperation. And the distinction matters because it shifts the burden entirely onto the federal government. If the federal government wants to enforce immigration law in Minnesota, it must do so using federal personnel, federal facilities, and federal procedures that comply with Minnesota's coordination requirements. Those personnel have been conducting operations in partnership with state and local law enforcement for decades, joint task forces, information sharing agreements, access to state criminal databases, use of county jails for federal detention. All of that depended on state cooperation that was assumed to be mandatory. It is no longer mandatory. States can withdraw. Counties can opt out. And if a state imposes coordination requirements, federal agents must comply or operate without any state involvement at all. According to unconfirmed reports from Department of Homeland Security internal assessments, enforcement capacity is projected to decline by 40 to 60% in jurisdictions that implement strict coordination protocols. Federal agents will still be able to operate, but they will need to do so more slowly, with advanced planning, and without the real-time intelligence and logistical support that state and local agencies previously provided. Immigration enforcement is the most visible example, but it is not the only one affected. Federal environmental enforcement often depends on state inspectors and state facility access. Federal labor enforcement relies on state wage and hour records. Federal consumer protection enforcement uses state court systems to obtain injunctions and restitution orders. If states begin treating federal enforcement the same way they now treat immigration enforcement, federal agencies will face a choice: comply with state procedures, or build entirely parallel systems that do not depend on state resources. The Supreme Court's ruling also addressed a second issue that is already causing chaos in lower courts. Can state courts interpret federal law more broadly or more narrowly than federal courts? The answer is no. The Supreme Court ruled that when state courts adjudicate federal claims, they must apply federal law as interpreted by federal courts. State courts cannot expand federal protections beyond what federal precedent requires, and they cannot contract federal protections below what federal precedent mandates. This dismantles decades of state court jurisprudence that used state constitutions to extend federal civil rights, employment protections, consumer safeguards, and environmental standards beyond what federal courts required. California courts have been interpreting federal anti-discrimination law more broadly than federal courts for 30 years. New York courts have applied federal consumer protection statutes more aggressively than the Federal Trade Commission. Minnesota courts have extended federal environmental standards to cover activities that federal courts excluded. All of that is now invalid. If the case involves a federal statute, state courts must apply federal interpretations. They can still apply state law more broadly, but they cannot use federal law as a floor and then build state protections on top of it by claiming they are just interpreting the federal statute differently. The result is thousands of pending cases that are now constitutionally defective. Employment discrimination cases that relied on state court interpretations of Title VII. Consumer fraud cases that relied on state court readings of federal trade regulation. Environmental enforcement actions that relied on state court applications of the Clean Water Act. Within 6 days of the ruling, at least 14 major corporations filed motions to dismiss or reconsider cases that had been pending in state courts under expansive state interpretations of federal law. They argued that under the Supreme Court's new ruling, the state court judgments were based on erroneous applications of federal law and must be vacated. State attorneys general from 22 states filed an emergency petition asking the Supreme Court to clarify whether the ruling applies retroactively to final judgments. The court has not responded. The assumption among most legal analysts is that it does apply retroactively, which would mean not just pending cases, but finalized settlements and judgments could be challenged. According to early indicators from state court administration offices, approximately 40,000 cases filed in state courts over the last decade involve federal statutory claims that were decided under state interpretive frameworks. Those cases represent billions of dollars in judgments, settlements, and enforcement actions. And all of them are now subject to challenge under the principle that state courts cannot interpret federal law independently of federal precedent. Minnesota was ground zero because that is where the conflict between federal enforcement and state sovereignty became visible in a way that could not be ignored. Federal agents and state officers were operating in the same jurisdiction under incompatible legal frameworks. Someone was going to get hurt, evidence was going to be suppressed, and the Supreme Court had to decide whether federal agents have unilateral authority or whether states retain sovereignty over law enforcement within their borders. They chose state sovereignty, not because they are anti-federal, because the Constitution requires it. But choosing state sovereignty in this context creates immediate operational dangers. Federal agents who have been operating with state cooperation for decades now face uncertainty about whether their operations comply with state law. If they conduct a raid without proper state coordination, they risk having evidence excluded. If they use state facilities without permission, they risk state prosecution for trespassing or unlawful detention. State officers face the mirror problem. If they cooperate with federal agents in ways that violate state coordination protocols, they can be sued under state law for facilitating unconstitutional enforcement. The result is not cooperation. It is caution. And in law enforcement, caution often means delay. Delay means targets flee, evidence is destroyed, threats escalate. If the current trajectory holds, we are entering a period where federal and state law enforcement will operate as separate systems within the same physical space, each constrained by the other's sovereignty, neither able to command cooperation. The Supreme Court did not create this problem. They exposed it. For decades, the federal government expanded enforcement authority by leveraging state resources without acknowledging that those resources belonged to sovereign governments that could withdraw consent. The system worked as long as states cooperated voluntarily. It collapses the moment states decide cooperation is no longer in their interest. This is not the story of one case. It is the documentation of the moment the federal enforcement architecture fractured. The 9-0 vote was not consensus. It was recognition. The justices looked at the constitutional structure and concluded that the shortcuts taken over the last 50 years could not be sustained. And millions of Americans will now live in a country where federal law is enforced differently depending on the state, the county, and the willingness of local governments to facilitate operations they cannot be forced to support. The emergency is not the ruling. The emergency is the system the ruling exposed.